ladies and gentlemen, come on in. I know it's been a long day. You're all very tired. This won't take too long. I'm doing an intro today. Come on in, you folks. Come on, I'll wait a second. Yeah, just take a seat anywhere there. Thank you. Okay, ladies and gentlemen, this is a CLE on Medicare set aside, otherwise known as an MSA or WC MSA. WC stands for Workers' Comp Medical Set Aside. How many of you are here are lawyers? Raise your hand. Lawyers? Okay, everybody's a lawyer. So we're talking about, when I say you, I'm referring to your client. Okay? Medicare, let me first give a cite. 42 Code of Federal Regulations 41146. That's what we're dealing with. That's where the law is for you to read and for your client to understand. Now, this will only take a couple of minutes. I know you're tired. It's been a long day. After this, I'm doing the introduction, then the experts come in who actually do the Medicare set aside, and they will give their presentation and also answer your questions too. So the main rule here is Medicare will not pay for Medicare covered medical expenses or Medicare covered RX prescription drugs related to your work related injury. The K there got cut off, but it is there, until the WC MSA funds have been exhausted. Okay? That is the standard rule. So we're talking about the work-related injury and how it affects the Medicare set-aside. Now, the Medicare set-aside, as you know, is a fund where funds are placed into in accordance with the Medicare set-aside documents that have established what that amount shall be. That is all established in the settlement documents and the MSA approved by CMS. Now, one thing to understand is that this is not a medical savings account. It has a similar acronym, MSA, but it's not a medical savings account, nor is it a health care savings account. These two items are tax-related issues. Tax professionals do these things for people who want some kind of tax advantage, for their clients who want a tax advantage, but they have nothing to do with this MSA. These are two different MSAs. Is that clear? Everybody understand that? Okay. So these two things are not to be confused with that MSA. These are for tax professionals, accountants, and tax lawyers who handle these affairs for their clients. I am not a tax lawyer, a tax professional, or an accountant, but these things are for those purposes, tax purposes, and they have nothing to do with this MSA or WC MSA. They are similar acronyms, but they are different. The MSA is a fund that, as I said, when the settlement documents are drawn up, it indicates how much money is to be put into that fund to pay for Medicare covered medical expenses. Now, another important thing to know is that work comp is a disability payment versus income to you or to the client. Okay? The income to the client. When we say you, we're talking about the client. Work comp is a disability payment. Now, I'm not a tax professional or accountant or tax lawyer, and I can't tell you for sure that work comp disability payment is never an income. But it was not set up to be an income. It was set up to be a disability payment. That is the basic rule. You should tell your clients, whenever you talk about tax issues, that you are not a tax professional, you are not giving them tax advice, and you are not an accountant. They have to actually talk about that with their tax professional. But the reason I want it to be stressed is that this is disability payment is to distinguish it from these two items, which are tax issues. Okay? Everybody got that? Anybody got any questions? Okay, we'll move on. The funds are personal to your client. They are personal to the client. In other words, it's not the government's money. It's no longer the insurance company's money. Once the settlement has been approved by both CMS, Center for Medicare and Medicaid Services, and the workers' compensation judge, the funds are personal to the client. A lot of people don't understand that. A lot of lawyers and clients don't understand that these funds do not belong to the government anymore, or never were, I should say. They never were the government's money, but they're no longer the insurance company's money. They are the personal funds of the client who signed the settlement. Medical services. Now, this is an important issue. Medical services, what is a medical service? It's clearly doctor bills. It's clearly prescription drugs. Could it be travel to and from the doctors? Medical mileage. Under Labor Code section, California Labor Code section 4600 allows medical mileage and other kinds of expenses related to medical expenses. The HUD regulations, HUD, Department of Housing and Urban Development. It's a federal agency, and they have a list of medical expenses that are related to medical care, and travel and lodging and medical mileage could be. Now, I'm not definitively saying it is or it isn't. I'm saying that it's allowed by other medical, other federal agencies. It's also allowed by the IRS. So it should be allowed here. And I would challenge each of you to look into that, because I think there's a good argument that, especially a client that you may have that's in a rural area and has to travel a long distance, the medical services can be deducted from the Medicare set-aside fund, any of the medical services. Okay? Now, when I say deducted, you know what I'm talking about. I'm talking about the client has a personal fund here, and they draw out the funds to reimburse themselves as they have paid out the expenses. Exhaust the WCMSA. We say here the main rule that the Medicare covered expenses, they will not pay for those in Medicare until they've used up the fund. And that's what exhausting WCMSA means. In other words, if your client has a large fund, let's say $500,000 in there per the settlement documents, and they use that whole $500,000, at that point they can now use Medicare for their work-related injury. They can now use Medicare. Everybody understand what I just said? Any questions? Okay, good. Now, the annual, tax issues again. Tax issues again, we mentioned that you should let your client know you are not a tax professional or an accountant or a tax lawyer, and that if they want to justify whether it's a disability payment or income each year as they pay taxes, they should consult their tax professional. But under the Labor Code, as you know, it's considered a disability payment, not income. But again, depending on what tax issues the client may have, you should refer them to their tax professional. Okay? Any questions on that? Okay, thanks. Annual reporting requirement. Every year that the MSA is still in existence, there is a reporting requirement. This is spelled out as a documents telling CMS, Centers for Medicare and Medicaid Services, what monies you have used. And this is in effect every year until you exhaust it, until the funds are exhausted by true medical services that have been deducted from it. Okay? So that's what we're talking about here. This doesn't last any specific amount of time. It lasts until what? Until the funds have been exhausted as reimbursement for medical services to the client to whom that fund belongs. Okay, so that's a brief introduction. Now we're going to take a little break, and then we'll have the Medicare set-aside professionals, experts, who do these and work them up and get them approved by CMS for us, discuss these issues too. Okay? So if you have any questions for me, you have any questions right now? Anybody? No. Okay, if you have any questions for me, you can see me at the break too. Okay? Thank you very much, and let's take a 5 or 10 minute break, and we'll call you back when we're ready. Thank you.